Madam Deputy Registrar, would you please commence the proceedings?
Thank you, President Saunders. Caribbean Court of Justice, Appellate Jurisdiction, on appeal from the Court of Appeal of Barbados, hearing of appeal in BBCR number 2 of 2023 between the Barbados Defence Force and David Anthony Harewood. The members of this morning's panel are Mr. Justice Saunders, President and Presiding Judge.
Good morning, everyone.
Mr. Justice Anderson.
Good morning, Counsel.
Madam Justice Rochnott-Lee.
Good morning, everyone.
Mr. Justice Barrow.
Good morning, everyone.
And Mr. Justice Jamadar.
Hi, good day to everyone.
May we have the appearances, please? Thank you.
May it please this court, Leslie Haynes appears on behalf of the appellant, and with me are my learned friends. To my left, extreme left, is Mr. Oliver Thomas, Principal State Counsel from the Office of the DPP. On my right is Mr. Noah Haynes, and to my immediate left is Mr. Kashawn Wood. Present behind me,
Sorry, go ahead.
Present behind me, I don't know if you can see him over my right shoulder, is Lieutenant Jamal Brown, beg your pardon. And on representing the Defence Force, also present on teams this morning is Captain Neville Corbin, Lieutenant Michael Griffith, Mikhail, I beg your pardon, Mikael, Mikhail Griffith. Those two should be on Zoom, on Teams, I beg your pardon.
Yes, good morning again to you all.
Good morning, Mr. President.
May it please this honorable court, Vincent Watson. I'm appearing for the respondent in this matter, David Anthony Harewood.
Yes, good morning again. Madam Justice Lee is having a little difficulty with her camera, so we would just pause for a minute or so. Is there an appearance for the Amicus?
Yes. Good morning. I am Melissa Stewart, attorney at law appearing for the Amicus Curiae, the regional security system.
I see. Okay. Good morning again to you, Ms. Stewart. Just bear with us for a little bit. I think we'll just adjourn for 2 minutes while we get that issue with Justice Rasnotli's camera sorted out. So if you can remain online, the judges will exit or mute, and we will begin again shortly. Okay, we're seeing Madam Justice Lee now. So, Mr. Haynes, are you ready to commence your submissions?
Yes, Mr. President. Let's go on. Well, firstly, members of the court, this is an important appeal with respect to the military, not only in Barbados, but including the region, the CARICOM region generally. You will note from the Court of Appeal judgment that the court-martial was a CARICOM court presided over by the president and 4 military officers from the region. The important issue, the extremely important issue, is the proper and is a proper understanding of Section 75 of the Defence Act of Barbados. And this Section 75, as the court is well aware, there is a similar section throughout the region, in the Defence Act throughout the region. There are similar sections in all Commonwealth Defence Acts, similar to that in the United States, Canada, Australia, etc. So that, in essence, I think I would like to refer to the submissions of my learned friend, Amicus, Miss Melissa Harewood Stewart, and take the court to her submissions, page 2089 of her submissions, under the heading failing to establish framework policy of unauthorized information gathering, conduct or unauthorized information gathering. I will take the court there eventually. But let me say at the outset that this appeal concerns, essentially, having stated generally it concerns Section 75, it also concerns the issue of information gathering, unauthorized information gathering. Section 3, the third charge in relation to the threat, that is not an issue before this court. It did not arise in the notice of appeal filed. And if it did implicitly, we are not pursuing any relief in respect of the third charge, that is the threat, knowledge of the threat, to the failure to communicate knowledge of the threat to the junior officer. The Court of Appeal, in essence, found that Section 75 offended against the principle of legality. We submit that Section 75, that the Court of Appeal erred in concluding that Section 75 so offended. We have cited to this court a number of authorities throughout the Commonwealth. We have, within our written submissions, we've set out the background to Section 75. We have cited a number of authorities from Canada, New Zealand, Australia, South Africa, India, that have dealt with the issue of Section 75. And none of them have found that, in fact, no case has been presented before this court or in the court below which concluded or found that Section 75 offended against the principle of legality. There's always a line to be drawn.
Just a minute, Mr. Haynes. There is one thing in saying that Section 75 offends against the principle of legality, and there's another thing in saying that a charge brought under Section 75 offended against the principles of certainty or legality, as the case may be. Which of the two did the Court of Appeal determine?
I am of the view, Your Honor, that the Court of Appeal determined the first one. That is, that it offended against Section 75, offense against the principle of legality. And in any event, we say, if the Court of Appeal found that the charge itself offended against the principle of legality, including Section 75, the charge itself under Section 75 offended against this principle, we say that the charge did not, because it was sufficiently particularized.
Okay, so you do, I take it in that response that you do concede that Section 75 could be perfectly constitutional, valid, but that a charge brought under Section 75 could offend the principle in question because it is not sufficiently particularized. Do you accept that?
Indeed, Your Honor.
Okay. Yes.
Just like, I mean, if we go back to basics, to the dangerous driving charge in traffic, road traffic, or the driving without due care and attention, or without reasonable considerations for others using the road, those charges likewise have to be properly particularized. So you must know that the issue is that, as was stated by the Court of Appeal, that and all the authorities cited, it's often very difficult to deal with the degree of human ingenuity under which certain circumstances will arise. So that you draft the offense as a broad one, and you give your particulars sufficient for the accused person to understand or ascertain the nature of the charge that he faces, that he has to defend.
Yes. So is your
What's the-
client, are you suggesting that A, but I know that you are, Section 75 is a valid offense, there's nothing unconstitutional about it. Are you further suggesting that the Court of Appeal ought to have upheld the conviction that was of the charge that was laid pursuant to Section 75?
But that is a different issue. Whether the Court of Appeal ought to have held that conviction is a matter of the evidence before the court.
And the Court of Appeal, as I understand it, did not go too much into that particular issue, having decided the first issue in a particular manner.
You have hit the nail on the head, Your Honor. The issue is that, let us assume for the time being that this court were to find that Section 75 does not offend against the principle of legality, and that the charge itself was sufficiently particularized so as to give the accused adequate notice of what he had to defend, what he had to answer. The Court of Appeal did not deal with the submissions of my learned friend on the issue of the sufficiency of evidence. Will this court deal with it, or will this court remit it back to the Court of Appeal? If this court were willing to deal with it, we would address that issue as well, on the sufficiency of the evidence. But secondly, so that's the point. That's one of the issues.
Yeah, Mr. Hayes, before you move off that point, on the question of the sufficient particularity, and when you develop this, I'd like to hear you a little bit more on it, and we can look at the charge that we are considering. I'm sure you'll do that with us. But you say you must be able to understand the nature of the charge and to have adequate notice to defend.
Indeed.
So it's still, I suppose I don't want to interrogate it now, but if that is the extent of your formulation of the test, then I abide it. But if in the course of your arguments before us this morning, you wish to clarify or nuance that test that you've just sort of ad-libbed to the president, and I accept that you were responding to him, then fair enough. But I would appreciate at some point a clear statement from you on what that test would be, i.e., if we get past the legality, the lawfulness of Section 75, what is the test for a court to ascertain the sufficiency of particulars? For example, are date and time and location relevant for an accused to know what the allegation is to be able to meet it? Is it sufficient to say between January and December of a year, something happened? As illustrative of what's in my mind. But I'm not going to do, I'm not asking you to address it or to ad-lib on it now. I'm just bringing it to your attention because you have summarized for us, I assume, the three stages in which you're going to proceed. Section 75, particularities of the charge, and then thirdly, sufficiency of evidence.
Indeed.
Yes, if I may say, President, thank you. I got bumped off of the laptop, had to use my phone, so I do apologize for any delay, any inconvenience caused, but I imagine that thankfully I'm back. I imagine, Mr. Haynes, too, that you will look at your charge 4, as Justice Jamada mentioned, and you will let us, you would address us on whether that charge in particular was sufficient, certain in law. Thank you.
And Mr. Haynes, if I may add to the two interventions already made, when you do, as has been suggested, could you draw the distinction between a summary of what the particulars should say and what the particulars should state? Thank you.
What the particulars should say and what they should not say?
No, the summary. So that you conducted unauthorized information gathering. That's a summary, because it could have gone on to say, in that on the 18th of January 2017, you met with O.S. Scott. On the 25th of February, you met with a person named Joel. And you list the 3 instances in which there were meetings, so that he would know that these 3 things or 10 things, whatever they are what constitute the gathering operation. Thank you.
Understood. Understood, my lord. To do so really is to change. I understand that the point that the court is making, but to do so really is to change and to turn the proceedings in the court martial itself and in the court of appeal on its head. Because it is my submission, it is our submission, that though the point in relation to the sufficiency of the charge or the issue in relation to the sufficiency of the charge was never made either at the court martial or at the court martial hearing or at the court of appeal hearing. Well, my understanding of the court of appeal hearing was that, and as stated by the court of appeal in, so let me say that the issue of the sufficiency of the charge, one should really let us deal with the issue of conspiracy. Conspiracy says that on such and such a date or between such and such a date you conspired with persons unknown or with persons A and B to do A, B, and C. So in truth and in fact, it will be conceded that it is conceded that the charge itself was drafted and I'm reading from page 9 of the judgment of the Court of Appeal. The charge itself says, conduct to the prejudice and of good order and military discipline contrary to Section 75 of the Defence Act, in that he, without lawful authority between the 1st of January 2018 and 30th of September 2018, at various places in Barbados, conducted unauthorized information gathering operations, conduct unbecoming of a commissioned officer in the Barbados Defence Force. In this particular issue, in this particular charge, there was never any issue of the information that was gathered, and that information was in relation to the threat, alleged threat, that was supposedly issued in respect of the junior officer.
Mr. Haynes, yeah, Mr. Haynes, just for my information, please. Are the words unauthorized information gathering operation some sort of term of art in the military? Because you
Perhaps
seem
I'll
to know
put
what it
that-
means, but I'm trying to be assisted.
Indeed, madam. Yes. I understand from my learned friend, representing the from my learned friend, Mr. Oliver Thomas, that there is really no it is understood. It is not a term of art, but it is understood really to be the collection of information in relation to certain investigations. So that,
Mr. Haynes, I
yes.
am intrigued by that reply, which speaks about the collection of information as distinct from, and I will ask you to perhaps expatiate, as distinct from the receipt of information. So the question whether he collected and whether he received information are different things, as you, I'm sure, even more than me, will appreciate. One is passive and the other is active.
That's the point. That's the point, sir. If you, and that's why I use the active word, because gathering to me was the active. If you sit down at the table, and you're in a restaurant and two men come at another table and decide that they're going to plan a heist of Republic Bank, you're collecting information as distinct from being active. In other words, you have information there. That person sit down next to the table next to you, you're hearing.
Right.
But you were not actively pursuing.
So you were not collecting information. The information came your way without your doing anything.
That's correct.
Yes.
So that gathering information, that is why I say it's an active. To me, gathering information is an active element.
We are an item. Thank you. Thank you.
But the charge, Mr. Haynes, if the charge, the essence of the charge is that he conducted unauthorized information gathering operations, that phrase, does it refer to the passive receipt of information? Does it refer to the active going out to actually assemble that, to get that information? And does the mere phrase sufficiently convey which of those two things he is being accused of?
I would say the answer to that, Your Honor, is that gathering, the submission is that gathering is an active, implies an active participation in the event rather than mere passivity.
Mr. Haynes, would you say the term confirms that because gathering is followed by operations? You have to take the whole thing, right? It is that he is, first of all, he is conducted, is put in the past tense, obviously, but conducted something. What was the something? Gathering, and we on active and passive with gathering, but gathering doesn't stand on its own. It is operations.
Indeed.
All right, yeah.
Indeed, sir. So, whilst I accept, or whilst our discussion here proceeds, it is important to note that these issues were really never placed clearly before the court-martial trial.
No, but Mr. Haynes, let's pause on that. Let's pause on that distinction, because you see, I do not for myself see a bright line between the pure Section 75 argument of legality and the related argument that we are chatting about now, because all of the case law across the Commonwealth and all of the academic writing across the Commonwealth accepts that Section 75 in all its forms and fashions is on the face of it vague. But what the case law and the custom and practices say is that with time, custom and practice, and with the formulation of a charge, the mischief of vagueness is tolerable. Let me use that expression, because of the overarching need of the military, like dangerous driving, etc., to have some open-ended category for discipline, etc. But that is not the end of it, because the jurisprudence links the argument of the legality of Section 75 to the practice of particularity. Is that not an accurate summary of what the jurisprudence has done, or do you have a different view?
No, I have a similar view, Your Honor. But what I'm saying, what I'm saying is this appeal was commenced for the simple reason that perhaps we say the Court of Appeal did not, in its judgment, did not deal with the matter with sufficient clarity. The Court of Appeal, when one reads the judgment of the Court of Appeal, and was as argued by my learned friend with the respondent, that in addition to Section 75, there should be attached to that some regulation or duty to be breached in order for there to be a breach of Section 75. In other words, so that is what essentially, that is what this appeal is about. Because if we had left it at that, it would mean that you could no longer charge someone under Section 75 for, let's say, to bring it to my mind, throwing garbage out of the window as a disciplinary.
Mr. Hayes, yeah, no, yeah, I think we understand that. But your answer to that is, you don't need formal regulations or SOPs. You don't need that. But you must, and I think you agree to the President, the inherent vagueness in 75 is cured by sufficiency of particulars.
Without a doubt, Your Honor. Without
Right.
a doubt.
So that we cannot, if you say that this is the big issue for Barbados and CARICOM, and you are inviting us, your position is, say that the Court of Appeal is wrong. Wrong in two regards. Wrong first by saying Section 75 is ipso facto vague and illegal. Also wrong in saying that Section 75 can only be saved if there is a written and known or published policy or protocol. Your answer to that is a very simple answer. No, all the jurisprudence in the Commonwealth says Section 75 is fine, provided, and you can't escape this, provided the fair hearing, the constitutional standards of fair hearing and protection of the law are met by sufficiency of particulars. Is that not your argument, Mr. Haynes?
Indeed it is, sir.
So we can't stop you. So I find it a little disappointing that what you want to do before us this morning is to say, look, well, I want to argue the Section 75 legality, but you don't want to condescend into the discussion on particulars.
No, I will get there, my lord. I will get there.
Right.
The point, Your Honor, the point that I'm trying to make is this, that the issues being raised by this court were never, to the best of my knowledge, not raised before the court-martial nor were they raised in the Court of Appeal, nor did the Court of Appeal deal with those issues in its judgment.
But Mr. Haynes, they are integral to your argument. They are integral to your argument. Are you saying that Section 75, without a sufficiency of particularity rider, is legal?
No, sir.
Exactly.
What I'm saying is this, that this court needs to deal with the judgment of the Court of Appeal, because if this court does not, it will stand as an authority that Section 75 by itself offends against the principle of legality, and that Section 75 cannot be used unless there's a breach of regulation or some standing order. That is the important point of this appeal. Not whether the accused man is convicted or is set free, or the conviction is overturned. That's a minor point in this appeal. This appeal really concerns Section 70, the understanding of what Section 75 can deal with from a matter of military or service personnel, in that it does not allow, Section 75 is to prevent in the military someone from behaving disorderly, someone from doing, as they say, human ingenuity can do anything. And it is taken, the military needs discipline more than anyone else. It's a higher level. So that is what this appeal is about from our perspective, from the perspective of the Barbados Defence Force.
So if I can interpret what you're saying, putting it a different way, you're saying that it was incumbent upon you, upon your clients, to bring this appeal, because if it didn't, the judgment of the Court of Appeal would give the impression that any charge brought contrary to Section 75 was bound to fail. Is that the case?
Any charge brought under Section 75, not accompanied by breach of a standing order or regulation or some directive, was bound to fail. Yes, Your Honor.
I see.
That is this. This authority should not be allowed to stand. As a secondary point, I understand the sufficiency of the particulars, and from that point of view, from the point of view of sufficiency of particulars, it is accepted that the particulars were insufficient, because the particulars of the information, at least of the information that was gathered between those dates, should have been put fair and square in the charge itself. The dates, you have a period of dates, so that is what this case is about. And I say that that argument in relation to the sufficiency of particulars was really never put before the court-martial, nor the Court of Appeal. That was not the argument. I don't know if there's anything else I can add to this situation.
For my part, no.
I think, yeah.
Thank you, my Lord. Thank you, Your Honor.
Yes. The only issue, it seems, is whether you are right in the view that a fair interpretation of the Court of Appeal's judgment is as you have suggested. Because if it is, then that's the only issue that arises here.
Well, if I may, through you, President, Mr. Haynes,
Yes,
if you are prepared to concede that the fourth charge lacked sufficient particularity, then is there very much more left for us to talk about? Because unless the other side is going to contest the issue of the legality of Section 75, then it seems to me that the path forward is quite clear.
or unless the other side, as I said, is going to suggest that a fair interpretation, and I'm not suggesting, a fair interpretation of the Court of Appeals judgment is not as counsel has suggested. And perhaps we could find that out from Mr. Watson.
Yes, but if I may, I just wanted to not to tie Mr. Haynes down at all, but just to be clear, you are in fact conceding that the fourth charge cannot stand for lack of specificity. Are you not?
I think you've said as much, Mr. Haynes.
I've said that, but that's the point. I don't know what to say again.
Okay, wonderful.
All I can say is, and I repeat myself, because having said that already, I repeat myself.
Okay. Those
were not arguments put before the court martial or before the court. The preliminary, the preliminary issue, as described by in the Court of Appeal and its judgment, is described in paragraph 54, started in 54 of the judgment, which says what concerned this panel was the more foundational or in limine issue of the offences charged themselves. A consideration of this issue in our opinion was potentially dispositive of the matter. The issue has to be settled before we can go on to consider the elements of the offences outlined or whether there's a sufficiency of evidence to prove the commission of these offences beyond reasonable doubt. And in paragraph 55, and it goes on from the judgment goes on from paragraphs 55 to 57. The point to be paragraph 57, quite evidently the two offences charged are not civil, brackets inclusive of criminal offences within our law. And therefore, in our opinion, the preliminary or in limine point to be settled is whether the two following offences of service, the two following offences are military or service criminal offences within the meaning of section 75 of the Act. Having knowledge of the threat of the life without a lawful authority conducting unauthorized activity. Stated differently, has the appellant been properly or appropriately charged? So that is our position, my lord. We say to this court, we say that the Court of Appeal judgment was probably right, but for the wrong reasons.
And you could not afford to leave those, and you couldn't afford to leave those reasons on the record, hence your appeal.
Indeed, yes, Your Honor. Correct.
Yes.
Okay.
Yes. Well,
President, before we move off, there's a very slight tweak I want to be clear on, Mr. Haynes. In the Court of Appeal judgment, I have found it a little unclear for me as to whether they were saying that Section 75 is vague ipso facto, or whether they are saying in this case the charges should not go on because the legality argument applies because there are no, I think they talk about regulations or stated military policy or practice. But the nuance I'm trying to clarify in my own mind is this, because it impacts what we may have to do or not do. You have just said to us, the Court of Appeal wrong to say the Section 75 charge can only stand if there's an accompanying policy, regulation, or practice. That's what you said just now.
Indeed.
Did the Court of Appeal say it as clearly as you did? Or are there hints that Section 75 is ipso facto vague to the point of illegality? It's important for obvious reasons. So I'm just troubling you a little bit because there's a paragraph here that this does not infuse a limitless scope. So anyway, let me not dwell on what I've read. Maybe you can assist me.
But that in itself was my quandary. I have not found any answer to that in my mind. But I have given the Court of Appeal the benefit of the doubt by saying that the Court of Appeal held that Section 75, without any regulations or standing orders, etc., practice, cannot stand. That Section 75 must be accompanied by certain other practices or standing orders or instructions.
Of which there was no evidence in this matter.
Of which there was no evidence in this matter. And
but they didn't go so far as to say, strike it out. They said, look, this is the policy position, and so if sometime in the future you pass regulations and policies, then you can charge pursuant to those regulations. You can charge pursuant to Section 75 when and if those policies come into force. That's how you understand it.
Indeed, that is my
right. Good.
That it gave the Court of Appeal, as I said, the benefit of all doubt.
Thank you.
Yeah, you see, it seems to me that what the Court of Appeal expected the military to do is to list in the form of a regulation or a policy every conceivable act that could be prejudicial to good order and military discipline. Whereas section simply speaks to conduct to the prejudice of good order and military discipline and leaves it to the military in the event that there is a breach of that to specify what the particular act is. It would be a very Herculean task, if it is even a possible task, because conduct that is prejudicial to good order and military discipline would vary with time and place and circumstance, so that it would be, I'm speaking off the cuff now, almost impossible to list in a regulation every conceivable act or conduct, behavior that is prejudicial. So to the extent that the Court of Appeal is suggesting that you must have that first listed in black and white before the offense can be charged, it's certainly problematic.
Indeed it is. Indeed it is, Your Honor. And that is what this appeal is about. Not whether the charge really. I understand an appeal is against an order, and the order of the court is that the appeal would have been dismissed. But behind that, and we submit a proper issue to the Caribbean Court of Justice, is to set out the extent of Section 75 as this, because we say as set out in this Court of Appeal judgment, it is not correct. And it is of sufficient...
Mr. President, can we maybe just ask Mr. Haynes, what is the fate of Lieutenant Harewood, given that what we've just discussed? What has happened to Lieutenant Harewood? Is it that he has been reinstated, or does he have all his full pension rights, or is it that his future also turns, his personal future also, or implications for him still turn on this appeal? Well, what has become of him in terms of the I think he was in the Coast Guard. Because cases are also about real people, right?
Indeed, it is about real people and setting precedents for the future. So that I think my learned friend, Mr. Watson, can confirm this and add anything to it if the court is so minded. My understanding is that he was dismissed. He has not been reinstated, but I'm not too sure. My learned friend, Mr. Watson, if the court allows it.
But Mr. Haynes, all right, but Mr. Haynes, if he is dismissed, doesn't that not have implications for his economic rights? If an officer in the army is dismissed as opposed to reaches retirement, etc., does that not impact his economic rights? And if so, how have they been impacted? And if it is that you've conceded, well, earlier the charge 3, and now virtually, I think, the charge 4, which therefore means that these proceedings against Harewood should not stand. But if the record remains that he is dismissed for disciplinary reasons, how do we redress that for him? What do you propose?
Mr. Watson has already taken steps, as I understand it, dealing with the issue of redress in relation to economic rights. I don't know how far he's gotten with those steps.
Well, I don't know that I find that comforting, because if before this court it is now agreed in relation, I take the point about what is important from the regional, etc. I take that point, but if it is before this court, we are now agreed from your point of view, from the prosecution's point of view, that there was no basis upon which Lieutenant Harewood should have been dismissed, then I think that is something which I must say, that should be solved right away and addressed right away.
We go back, Your Honor. We go back to the point that we have arrived at the CCJ, at the Caribbean Court of Justice, without the issue of the sufficiency of the charge being dealt with either at the court-martial or at the Court of Appeal level. So this is being raised for the first time.
Well, I won't say anything more. I will leave it for my more senior brothers and sisters to maybe ask anything more.
Yeah. Mr. Haynes, there's one question that I wanted to get some clarity on. The Court of Appeal ordered, or they said that the decision of the court-martial should be quashed, and it is so ordered. What was the impact or effect of that order on Lieutenant Harewood's commission?
On his commission, he has never been,
or his position.
He has not returned to the Barbados Defence Force.
Can I ask you a different way? Can he return according to the law? Should he return, I should ask?
I would imagine Mr. Haynes' position is that he has not been engaged by the Barbados Defence Force to advise them as to what steps they should take in relation to any decision pronounced by any judicial tribunal, and therefore he will await an engagement in that regard if the authorities are so minded.
And I just put it better than I could have stated it myself.
Well, but President, my concern, my angst is not relieved, because the order of the Court of Appeal is an order of the court. And I think what our sister has brought our attention is that the court-martial is quashed. And so as a question of law, if it is quashed, then he was never terminated. He was never, so his status must be his status ante in law.
Indeed. And there is a remedy for that.
All right.
But I assume, Mr. Haynes, that the final remedies that will be applicable would await the decision of this court, because you had appealed from the decision of the Court of Appeal, and therefore, until this court has pronounced, I assume, uncertain as to what the rights of the lieutenant would be.
To an extent.
Yes. Okay.
Yes. Well, if there's nothing more, Mr. Haynes, then we will hear from Mr. Watson.
Thank you, sir.
Yes, thank you. Yes, Mr. Watson.
Morning, sir. Now, sir, in view of Council's submission and concession, I am of the view that little I can add, other than perhaps to clear up perhaps any misconceptions which may have been said in relation to the judgment of the Court of Appeal. I am of the view that the court appeared to have been saying that any practice, even a directive, once an accused person was aware of that directive, would have been sufficient to constitute charges under Section 75. So, consequently, the terminology formal or informal, as used by the court in brackets. So, to me, the Court of Appeal's decision was erudite, and it actually went through a number of stages, step by step, in coming to the conclusion that it did. So the court in principle said that, look, vagueness alone does not cause a piece of legislation to be at an end. Vagueness is not a standalone test. And it quoted authority to that effect. So it is not then true to suggest that the Court of Appeal was not thorough in its decision making. Now, I just wanted to add, one statement in respect of the submissions by counsel. I would suggest that the objection to the minimum standard identified by the Court of Appeal kind of harkens back to an earlier stage in the development of the law, where commanders in the Defense Force were able to identify a breach and exercise punishment to a soldier on account of that breach, there being no written guidance as to the particular type of breach. The Court of Appeal is clear that the law is fluid and it takes account of changing circumstances. That's what the case of Sabbatry says. So there is an authority, the case of Regina versus Boyd, which in principle suggests that modern thinking on disciplinary rules and procedure really suggests that there are three principles which a disciplinary code should take into account. And the most significant of the principles is the principle against arbitrariness, the principle against there being some kind of arbitrary decision by commanders in the force. Indeed, what Tree says is that whatever the practice in former times, a modern code of military discipline cannot depend on arbitrary decision making. And what we're saying is that the Court of Appeal is correct when it says that there must be at least some minimum standard, evidence established and known to be a soldier before there can be a charge.
Can I ask you, Mr. Watson, would that certainty that's required be supplied if there was sufficiency of particulars given? In other words, if we have Section 75 and we have the charge, and the charge is sufficiently particularized, in your view, is that sufficient, or do we need to go further and have these practices in writing or regulations, etc.?
That would be sufficiently particularized. In principle, the prosecution would then be able to produce evidence as to the specific particulars. And Section 75 would indeed cover such a charge, even though it might be new. In other words, something unknown to the section.
Right. So if I understand you, you're not saying very much different from Mr. Haynes.
We're not. That's the reason why I said there's little that I could add to the submission, given his concession.
Okay.
Yeah, Mr.
So-
Watson.
Yeah, go ahead.
Yes, thank you, President. Mr. Watson, I got the impression to looking at paragraph 100 of the Court of Appeal judgment over page at subparagraph 4, perhaps, that they thought that something more was required in this case because of the term unauthorized information gathering operations, which seemed by themselves to be vague. I got the impression that they were saying there should be some framework, formal or informal, or military, or Barbados Defence Force policy or regulation known to officers and other ranks alike, establishing or defining what constitutes authorized, or for that matter, they say unauthorized or authorized information gathering operations. So could even if there were particulars cure what the Court of Appeal saw as having been required and not having been standard, not having been met?
Well, I think the Court of Appeal was particularizing its statement to this particular case, because it had the service knowledge of a witness, which indicated that such a policy, and she was in a position of some prominence.
That witness is who? Just let us know. So
This was Major Wendy Harewood.
Yes.
So she was saying that she never heard of such a policy. So I think that the statement of the Court of Appeal, having taken that into account, was kind of making the point that the prosecution had not satisfied the court that, yes, the particulars of the offense, but also in the setup to suggesting that someone had breached the law, then they would have had to be those particulars to make out the offense.
Do you share, Mr. Watson, Mr. Haynes's view that the Court of Appeal's judgment suggests that the nature of any specific misconduct that could be charged contrary to Section 75 should be listed in a regulation, a stipulation, a direction, or some other form in black and white prior to the particular conduct or misconduct being engaged in?
I am of the view that the issue may not necessarily be black and white. The issue could very well be a practice that is known. Now, it would make sense if that practice was written.
No, what I'm asking you is your interpretation of what the Court of Appeal's judgment says, because it is on the basis of that interpretation whether it would become necessary for us to modify, so to speak, or even disagree with the Court of Appeal or whether the Court of Appeal's judgment did not require an appeal. The question is whether a fair and balanced reading of the judgment of the Court of Appeal suggests, because, let me back up a little bit. We are arguing about two things here. One is whether the particular misconduct that is said to be in breach of Section 75, whether the particular misconduct should be brought home to the accused person before, or it should be evident in writing before the accused person did what they did, or whether it is sufficient for the particular misconduct that is said to be in breach of Section 75 to be specified to the accused person when they have engaged in that misconduct and are being charged with it. Do you understand the difference between the two things?
I do, sir. It should be evidence in writing before charge.
So then you agree with the Court of Appeals.
Yes.
You agree with Mr. Haynes's interpretation of what the Court of Appeals says.
Yes, sir. My position is that it should be in writing so that a person knows
before the person
the charge.
Embarks before the charge.
Before the
I see.
charge.
So that puts an onus on every military establishment to conceive of every particular circumstance in which good order and prejudice can be breached, and to lay them out so that persons are appropriately forewarned, as distinct from a situation where you assume that you're a military officer, you have been indoctrinated into the military, you have certain training, and you have a sufficient understanding of what is good order and prejudice, such that if you engage in conduct that is contrary to good order and prejudice, we merely need to, when charging you, specify in the various respects in which you have misconducted yourself and not achieved good order and prejudice. Even if the particular misconduct was not laid out in a policy, a direction, a regulation, as the case may be. That, it seems to me, is where you and Mr. Haynes differ. You believe that it must be laid out, as the Court of Appeal says, and Mr. Haynes and his client suggest that no, it's too great a burden on a military establishment to expect them to lay that all out, because it's a fluid situation.
I think CARICOM supports that latter position. We may hear from the Amicus, but I believe the CARICOM position lines up with what you've just articulated. Just to include the Amicus in what you're saying.
Yeah, but President, I too would like to let us look closely at the Court of Appeal judgment, because I am not sure that the Court of Appeal is saying that there should be such a rigorous test. I thought at the same paragraph 100 and sub 4 that the judge there was speaking about there must be some framework, she says, formal or informal. I didn't get the impression that she was saying there must be a standard operating procedure. There must be something in writing, because as you say, that would be very onerous. That would be an impossible task. But I got the impression that there must be, and I think I agree with Mr. Watson. I think in answer to me, he was saying that they were looking specifically at this charge 4, which dealt with unauthorized information gathering operations, and saying, look, that is so vague that doesn't fall within any framework that we have heard of or any witness gave testimony of. That is the impression I get, but I'm not sure President of the Court of Appeal was actually saying it must be in writing. There must be a procedure or in writing, or else one could not proceed. But again, I would like to look more deeply at it.
I thought in response to a question I'd asked you, Mr. Watson, that I thought that you were conceding that all that was required to be combined with Section 75 was sufficient particulars of the charge, and not the need to have particular modes of conduct enumerated in a regulation or any other such thing. In fact, if you were to have taken that second approach, that would be rather contrary to the authorities that we have been exposed to, wouldn't it? The jurisprudence? The question.
No, that is correct, sir. Certainly the case of Sabbath 3 does indicate that the ceiling is very low, but there must be something, formal or informal, so that a person is aware as to the conduct that they must subscribe or not subscribe to.
And that ceiling, which is very low, is that built on, for example, the enlistment in the force, the training that the person receives, the traditions to which they have now become accustomed, that they know are applicable, or you are insisting on something more than just that?
I would suggest that it might be more than just that. Given the history of this particular provision, which in principle saw commanders acting arbitrarily. So it should be a little bit more than merely the thought of a senior officer. Consequently, perhaps a practice, yes. Something in writing, yes. But in all instances, it perhaps would depend on the circumstances of the case.
And when you say commanders acting arbitrarily, you mean in terms of issuing charges, and in terms of charging persons?
In other words, having seen something, made a determination that it is contrary to the code, and without the knowledge of the accused person, bringing a charge against that person. I mean, that used to be history.
Right. But then it would fall to the body that is hearing that charge to hold the balance, to say, well, no, this charge is really arbitrary,
That's a safeguard.
Yeah.
President, if I may?
Yes, certainly, go ahead.
Yes. Mr. Watson, what is striking about the need for the person charged to be aware of the standard to which they are being held? What is striking is that if one looks at the evidence of the interview of Mr. Harewood, it is clear that Mr. Harewood knew that even the receipt of information of this nature required him to consult with, to inform his superiors of the receipt of this information. So it's not a question of information gathering, operation, etc. Mr. Harewood knew that he should tell military intelligence of the information he received. He knew that he should tell the commanding officer of this information. I think he told about 2 or 3 other persons at various stages of his receipt of information. So it seems to me that it would be a matter of course for an officer to know that there is a certain mode of conduct which requires approval, sanction, authorization, or acceptance. So I am not clear that in relation to something of this nature, and I think this is it, it has to vary from instance to instance or situation to situation. But to my mind, it is clear that Harewood, were he properly charged, would have known what it is that he did that he ought not to have done? Help me there. I think he's frozen. No?
No, he's okay.
I would take the point that the information, it was alleged that Harewood collected was of a serious nature.
Sorry, hold on. Don't prejudice your client. Not that he collected, that he received.
That he received. However, the evidence suggested that such information should be reported to superiors, not specifying who it should be reported to. So I can't agree with your position that Mr. Yearwood understood that perhaps there was a duty to report.
But if he reported it, why did he report it if there was not a duty?
No, that there was.
Yeah, but I'm saying he reported it.
Correctly so.
So if he reported it, then clearly he understood implicitly that there was a duty to report.
The nature of the force, that's correct. He knew there was a duty to report. So in this case, yes. But the difficulty, sir, is that, and this was the last point that counsel had made in his submissions, ground E, where the Court of Appeal in principle was saying that there's a situation that needs to be remedied, it being the persons to whom information, say, of this nature should be reported. Now, the general principle in the force was that you report to your superior. In this case, the reporting appeared to have been to his superiors.
Mr. Watson, I am not sure that this court is being asked to make a determination as to whom the report or a report should be made. It is simply the question whether a charge formulated in this fashion without the particulars is a properly made out charge.
Our position is it's not properly made out.
Right, and Mr. Haynes concedes to that. So to my mind, the appeal is finished.
Yes.
Which leads us, I think, at some point, and I suspect you will decide when that point arrives, as to the remedy that you were seeking. I think we started a discussion about that earlier. In terms of the order you'd want the court to make, or any other issue related to the rights of your client in light of all that was said this morning. At some point, I assume you're going to address us on that?
Yes, sir. So I can say in answer to one of your, I think your sister's question, that your brother's question, Mr. Harewood has been vilified, unable to find employment, and indeed has suffered over the last 3-4 years. There is a job he recently got as a person in security. Now, I think that given there's obviously a breakdown of trust and confidence between the parties, I take it that the reinstatement to his former position is out of the question, given that breakdown of trust. So in these circumstances, damages for, and of course, right, damages would be an appropriate remedy in these circumstances.
Sorry, Mr. Watson. May I go ahead, President, or you?
Yes, no, you go ahead, go ahead.
Mr. Watson, there is not an appeal by Mr. Harewood before us. There is an appeal by the force against the decision of the Court of Appeal. So it is for us to decide appeal allowed, appeal dismissed. And to my mind, that would mark the fulfillment by this court of its remit. What steps flow from that, I think, would be a matter of, I don't know how we can go any further, and it is for you to tell us how we can go any further. But an award of damages, I do not know that that is on the table at all for us. Tell me, am I wrong?
You are not wrong, sir. So I was merely addressing the issue was raised by your brother in terms of the present status of Mr. Harewood.
So in terms of the what?
In terms of the status of Mr. Harewood.
Oh, yeah. Well, obviously, we are all very concerned. And the question is, what, if anything, can we do? I know that there are other things which may need to be done, maybe by a different court, by a resumption of the court martial. I don't know. So I think what we are seeking is for you to assist us as to what we can do, not what needs to be done.
Well, at this point in time, this court's hands are tied in terms of what it can do. What is presently before it really is whether or not there is merit in this appeal. And I think that if the court rules in a particular direction, we then can take what other action we have to take in Barbados.
Okay, sure. Okay. All right, thank you very much. We just heard from Ms. Stewart.
Thank you,
is there anything in light of the discussion that you've heard, submissions that you'd like to address us on?
Yes, Your Honors. As it relates to, I think Counsel Mr. Haynes, he highlighted the most serious issue for consideration at this appeal court as it relates to the charge of Section 75, whether it has to be, whether there must be a regulation, whether the charge must be based on some regulation policy in existence before. Within the military, it would be difficult, as you would have said, Your Honor, to highlight or to list all the different types of conduct that would be in breach of Section 75. What I'd like to point out to the court is that these offenses that were charged against Mr. Harewood, these offenses, the conduct were not stated, or there was no policy per se against it, against his conduct. But based on his rank, based on his appointment, based on his relationship, there are certain expectations or certain conduct is expected of him. So for example, with the charge of failing to report the threat, based on his relationship with his subordinate rank, a duty would have arisen for him to report that threat of his subordinate rank. Because he is responsible for the welfare of the rank subordinate to him. So based on that relationship alone, a certain conduct is expected of him. Secondly, in relation to the offense of conducting unauthorized information gathering. Now, I don't want to go necessarily to the facts of the case, or to what was proven or not proven, but his authority would have arisen. It doesn't have to be based on a written policy per se. His authority to act in the military arises based on his rank and based on his appointment in the military. So that if he acts outside that scope of authority, then he would be conducting himself in breach of Section 75. So those are just the thoughts I wanted to add in relation to the offences, that it can arise. Commission of defense can occur based on, it can be implied, based on, could be the relationship, based on the rank of the accused. And in this case also, as was said previously, we can look also at the experience of the accused. Like in this case, as relates to the reporting channels, the evidence showed that, and this is from the accused, that previously he would have reported this issue to the chief of staff directly.
Ms. Stewart, can I ask you something? You know, things like lines of reporting, because one of the things that struck me in this case is that he did report stuff, but the question, the criticism was, you know, about the precision of reporting and to whom he should have acted. For example, you know, the gathering of information, operations gathering information. Is there the Court of Appeals sort of criticism is in 106, the vagueness of Section 75 has not been mitigated by evidence of relevant law regulations made pursuant to the Act or stated military policy or practice. While accepting the inherent jurisdiction of the BDF, the Barbados Defence Force, to exercise disciplinary control over its members, this does not automatically translate into infusing a limitless scope to Section 75 or the creation of criminal offences without due process. So there are two little things going on there, but why is it sort of anathema to create a line of reporting policy? Why is that? Okay, so that I get you cannot cater for everything, but does that mean you should not cater for anything? For example, you talk about your status, your rank, and so on, based on rank and authority, based on the scope of authority, and so. So, is there? Do all these officers have job descriptions? Do you develop a job description for a lieutenant? And does the Defence Force have a policy, and should it have a policy that says, in terms of reporting, so it doesn't have to be specific for a specific offence, but it could be generally in terms of lines of reporting, that the expectation is that where there are matters of grave concern or serious, even that word, they should be reported and reported according to some chain of command. So it doesn't have to be, because, for example, this offense, that the one that we're left with, conducted unauthorized information gathering operations. Suppose he was actually conducting, without authority, information gathering around the sale of lollipops of a certain brand in Barbados. Now, you may say that is fanciful, but I use the hypothetical to make the point. Is there a value? I think that was the Court of Appeals concern. Is there a value in having some policies in place? The impression I got when I read I'm still reading through the transcript, I must confess, it's a lot. It reminded me of the years of practice, and I realized how burdensome those years were when you get into what should be admitted and not, but leave that aside. I formed an impression that there are no extant policies on these general things. Is that correct? Something as basic as lines of reporting. And this case seems to expose that, does it? Who should he have reported to? He reported to somebody, didn't satisfy, and therefore I think charge 3 is laid. So I don't know, maybe I've missed something, but how would you respond to, so is it 0 or 100, or is there a need and room for something in between? I think that's what Mr. Watson may have been sort of pointing to. I'm not quite sure.
Yes, Your Honor. if I may, as it relates to the reporting channels. Now, in the military, where there is intelligence or information reported, there is, as the evidence would have been shown at the court-martial, there is the Military Intelligence Unit, the G3 branch, and Guyana, I think, is the G2 branch, where that information is passed to and filtered. There is no written, but because of how the military operates,
I understand what you're saying, but you see,
but
part of what I'm asking is why not? For example, when these officers come in, they do training, don't they? They are trained. Are they training manuals? Has the military developed training manuals that you train people by, and a new officer gets a training manual and it talks about, okay, you know, this is what should be done, or do you just learn it? How are they expected to learn and know this? How are they taught this?
As relates specifically to the intelligence, I can't say specifically how they would have been taught that, save and except if they were at that unit specifically. If they were at the intelligence branch unit, then they would definitely know the chain of command as relates to when it comes to intelligence information, what to do with it.
So, all right, fair enough. So that if an officer, if a lieutenant, you knew that a lieutenant knew about this, but there is another lieutenant who did not know about this because they were not exposed, is it that one could be charged because by happen chance they knew, and the other who would do the same thing but by happen chance does not know would not be charged? Or is it that both could be charged? And if both could be charged, then in the second example, is it fair to the other if what you are saying to us is, well, I don't know how it's taught, there is no manual, there's no training manual, there are no guidelines, but if they come across it, they know about it and they're expected to know about it? Don't you find that feels very, I would say, arbitrary?
Your Honor, if I may, there is, not necessarily in this offense, but I know of other offenses where that same issue arises, where the question is, where the particulars drafted states the accused knew or he was reasonably expected to. Question of being reasonably expected to know turns on his experience in the military and things like that, his experience, his training, and so on. So it may be different. Yes, it may be different based on the facts of the case. I think that is why this particular charge, when you read the cases of Armstrong and R, it says it's an objective one based on the facts of the case, based on the evidence presented. So it may be that in a particular case, an accused person, let's say in another case where if the accused person was maybe just in the army for 1 year, may not have that experience as Mr. Harewood did for 18 years, that may be difficult to hold him to that same standard.
Okay.
Because he would not have been reasonably expected to know.
So you don't think there is a value in having these general things put into policies, lines of reporting, so that people could come in and study it from the time they get go and they can know and it can be transparent and clear and help? You don't think there's a value in that, do you?
I do think there's a value in it. However, the issue with Section 75 is that it caters for those instances where that may not have been provided for, but it is still a question of misconduct.
Yeah, exactly. But if in a situation of, so that I understand Section 75, you want to leave it open-ended, but what if there is a situation where it could easily have been addressed? For example, reporting lines. So there could be a situation that you have Section 75(4) that comes up, but you can have certain situations such as reporting lines, which whether or not it intersects with Section 75 is a general thing.
Yes.
Because you have to be very careful that you don't say we need Section 75 to be open, so we don't need to regulate to have guidelines because we have Section 75. But that is actually a little bit of, if I may say respectfully, a bit of a flawed assessment, in my opinion, respectfully, because you could need the openness of Section 75, but that does not mean that you cannot regulate and create policies where you can. The things are not mutually exclusive. They're not. And even when you create policies, Section 75 can still operate in the gaps. Can't it not? And would that not be a fairer, more accountable, more transparent organization of affairs? It doesn't throw Section 75 out. It allows it to operate in gaps, but it also creates a duty to create regulations and policies where you can.
Yes.
Anyways, those are just the things I'm thinking about, so never mind.
Okay, and I also would like to point out as well that some regulations may become standing orders, and may be orders. So in those cases, when we have conduct in breach of those orders, a specific section in the Defense Act that caters for that. So Section 75 really, when you read the Manual of Military Law, it really caters for the conduct that is not captured in the other military offenses. In our jurisdiction, to be Sections 33 all the way to Section 74 of the Defense Act.
Yeah, thank you.
Okay, is there anything else that you'd like to tell us, Ms. Stewart?
No, you want. Those are just the points I wanted to add to the discussion.
Okay, thank you. Mr. Haynes, I don't know that there's anything that you would want to tell us in reply, is there?
Well, Ms. Stewart preempted me in relation to the other sections and the military law, filling in the gaps, etc. So, but I just, apart from that, in relation to the question of the response to Justice Jamada, at paragraph 64 of the judgment, you will see there set out the submissions made by counsel for the appellant to the Court of Appeal, which clearly set out there being no that you must have some sort of, as the Court of Appeal said, there should be some framework, formal and informal, but we say that Section 75 does not really deal with that. Section 75 is to catch everything else. That's all. I don't know if I could assist the court then.
Yes, okay. Okay, well, thank you, counsel. We will take time to give our decision on whether we uphold the appeal in its entirety, or whether we would suggest that some elements of the manner in which the law is phrased should be nuanced, and we would let you know when we are ready with our decision. So I just want to thank you all. I want to thank in particular the Amicus, Ms. Stewart, and I wish you all a good morning.
President, if I may?
Yes, yes.
I would like to pay tribute to those who conducted the proceedings before the court-martial, Mr. Watson and I think Mr. Lieutenant Bourne. I think the forensic talent and reliability displayed deserve commendation, and I therefore am grateful for this opportunity.
Thank you, sir.
Yes, indeed, and Justice Barrow certainly speaks for all of us in that regard. Okay, Mrs. Thomas Roberts, Deputy Registrar, would you please conclude the proceedings?
Thank you, President Saunders. Thank you, Mr. Justice Anderson. Thank you, Madam Justice Rogers-Lee. Thank you, Mr. Justice Barrow. Thank you, Mr. Justice Jamada. Thank you, Counsel. And thank you to the staff of the Caribbean Court of Justice. This court now stands adjourned. Good day to all. Thank you.
Thank you.